Okay, we're live now. So, welcome everyone. Hello, and welcome to another session of hashtag Mentoras sponsored by Lawyered. Today's topic is design registration, protection, and infringement under Indian law. And I'm very proud to welcome a very special guest, advocate Rakesh Tiwari. Rakesh Tiwari, sir, good evening to you and welcome. We're very glad to have you here. So, a little bit of background about Rakesh Tiwari, sir. He's been a practicing advocate since 2010 and is an IPR attorney as well as a legal consultant who specializes in trademark, copyright design, patent, geographical indications, and due diligence for IP rights, IP and corporate enforcement of intellectual property. Apart from these specializations, Rakesh sir also works in certain areas like business and company registration, winding up, and consumer protection law. Rakesh Tiwari sir, we're very, very honored to have you on our panel today. Thank you very much. Just before we begin, just before we begin, I'd just like to remind everyone we'll be sharing the registration link and the attendance link on the chat box over there. Secondly, we will also kindly request all of you to keep yourselves on mute. The only person who we'd like to hear during the entire webinar is Rakesh Tiwari sir. And finally, if you all have any questions during the interview, during the webinar, please do not turn on your microphones. Please send the questions into the chat box and we will be addressing them at the end of the webinar. Thank you, sir.
Thank you, Sameer and Lawyered team for inviting me. A very good topic. That is, we'll discuss today about design registration, protection, and infringement of design under Indian laws. Friends, design is one of the categories of IPR, where the design system focuses on the aesthetic features of an article derived from its visual appearance. For this, Design Act 2000 come into the force, and it is a kind of complete code for protection. Under it is wholly statutory in nature. It contains 48 sections and 11 chapters. Section 2D of Design Act says, design means only the features of shape, configuration, pattern, ornament, or composition of lines or color applied to any article, whether in 2-dimensional or 3-dimensional, or in both form, by any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which in the finished article appeal to are judged solely by the eye, but does not include any mode or principle of construction or anything which is substance a mere mechanical device, and does not include any trademark defined under Trademark Act or property mark as defined under section 479 of Indian Penal Code, or any artistic work as defined in clause C of section 2 of Copyright Act 1957. Now, there are two terms which we have to first discuss. What is article? And as per the Design Act, article means section 2A of Design Act, which describe article means any article of manufacture or any substance, artificial or partly artificial, partly natural, and includes any part of an article capable of being made and sold separately. It's the main objective of Design Act is to protect the new and original design from getting copied, which causes loss to the proprietor who has invented, who has created this unique design. The issues under the Design Act have recently increased as organizations want to safeguard the aesthetic value of their products. Now, there are some conditions, there are some requisites which are required for registration of any design, because without it, it cannot register. First condition is it should be novel and original. It should be applicable to the functional article. It should be visible on finished article, and there should be no prior publication or disclosure to the design, because if it is prior published and if all four conditions are not fulfilled, it cannot be registered under Design Act. Now there are classification of goods, which kind of which classes the goods falls. These classifications has taken from the Locarno classification, and Locarno classification established by Locarno Agreement 1968 is an international classification used for purposes of registration of industrial design. Application for registration of design applied to an article are classified according to the third schedule of Design Rules 2001 for its classification. Designs are registered in different classes as per the Locarno which we have discussed, and because because there are 32 classes, and which design, if anyone want to register their design, they have to go through the which class it falls, and thereafter they may file application for registration of design. The objective of behind the registration is to protect new and original design created by the proprietor, by the labor and unique skill, and creators and proprietors have a right to prevent all others from producing, importing, selling, distributing products having an identical appearance or fraudulent or obvious imitation. The Design Act should not be confused with a Copyright Act, because there are many products which can be registered under both the acts, but their remedies cannot be sought in both the acts individually. Now, I will just brief some differences between copyright and design. The first differences is copyright is an automatic right which protects original literary, dramatic, musical, artistic work. A design rights protects the visual appearance of an object or a part of an object. Second differences is bare perusal of Copyright Act 1957 would reveal that copyright subsists is an original work which grants the author an exclusive right over such work. In case of design, design defines an external features that is applied to an article, judged solely by the eye. Protection under Copyright Acts starts when the work creates in a tangible form, and we can say when the work gets a tangible form, but only when the design is registered it is protected, meaning thereby protection under Design Act is only granted when the design is registered. But in case of copyright, when the work get tangible form, we can seek a remedy under Copyright Act. And fourth difference is copyright is an inherent right, whereas design is a statutory right as per the Design Act 2000. And the owner of design will have to forego protection under copyright laws once the design has been granted registration. And the recent one of the case of landmark cases, Ritika Private Limited versus Viva Apparels Private Limited. In this case, Honorable Delhi High Court held that the copyright in an unregistered design shall cease as soon as the article to which design has been applied has been reproduced more than 50 times by an industrial process. So in this way, we can differentiate copyright and design. Now, we will go for design right and right of proprietor. What is the effect of registration? The registered proprietor has exclusive right to the to apply a registered design to article in class which design is registered. Registered proprietor has right to obtain by design registration and exclusive right to use it, to export it, to sell it. And registered proprietor can give that design to the third person as a license basis, or it can be assigned. In case of any infringement, damages can be claimed by the registered proprietor. Any registered design is valid for a period of 10 years when from the date of application. When a proprietor applies for registration of design, he shall automatically get copyright in design for the period of 10 years from the date of registration. These 10 years term may be extended for a period of 5 years by filing renewable fees. Now, what is the process of registration of design? There is a simple process. It's not a technical one. We have to follow in such process. Application duly filed in Form 1 along with the prescribed fees, stating name and full address, nationality of applicant. If the applicant is a natural person, the legal status and place of incorporation. Second is the name of article to which the design is to be applied, class, and if any subclass, we have to mention the article embodying the design is applied under the Locarno classification, and representation illustrating the views of article wherein originality lies. Representation can be in the form of photographs, drawing, figures, showing perspective view, front, rear, top, bottom, and side view of articles. 2 copies of each. If the design is to be registered in more than one class, a separate application shall be filed for more than one classes. Then thereafter, statement of novelty, disclaimer if any, in respect of mechanical action, trademark, word, letter, numeral should be endorsed on each representation sheet and should be duly signed and dated. And when the color combination is the essence of a design as applied to an article, the same shall be clearly depicted in the representation sheet. And after filing of the application on Form 1, the application may proceed for examination and Design Office Kolkata, and thereafter objection, if any objection issued, first examination report was issued, and thereafter if any objection raised by the controller, it can be removed within a prescribed period of time by the applicant, and after removal of the objection, the certificate granting copyright and registered design is issued by the design office. Now, there are some, we have already discussed that there are some conditions which are required for any kind of design registration, because there are 4 conditions which every design has to fulfill. It should be novel and original. It should be applicable to functional article. It should be visible on finished article. There should be no prior publication or disclosure. And Section 4 of Design Act also talks about item that cannot be registered as a design under the act. What Section 4 says? Section 4 says a design which is not a new original or has been disclosed to public anywhere in the India or in any country by publication or any tangible form or by use of any other way prior to the filing date, or where applicable the priority date of the application of registration, or is not significantly distinguished from the known design or combination of known design, or comprises or contains scandalous or obscene matter, shall not be registered. Section 4 of Design Act say that which kind of design cannot be registered under the Design Act. Now, if in such categories which we have discussed, if design is not new and original, it has already been disclosed to the public, and comprises contain scandalous and obscene matter, it cannot be registered at all under Design Act. Now, if the design is registered and anyone have grievances against that, this design is already available to the public domain, and why the controller has granted such kind of registration. There is a procedure uh, which say cancellation of design registration. It say section 19 of design acts talk about this cancellation of design of registration. This provides petition for filing before controller for cancellation or of rectification of design. There are certain grounds. First is the design has been previously registered in India, or that it has been published in India or in any other country prior to the date of registration, or the design is not a new or original one, or the design is not registrable under this act as per section 4, and it is not designed as defined under the clause 2D of Design Act, now which we have already elaborated. Now after registration, if anyone had registration and thereafter the procedure for cancellation, and suppose if anyone has registered a proprietor of any design, and what is the remedy, how they can seek a remedy from the court, and what is remedy available against piracy of registered design. In India, piracy of design means the application of design or its imitation to any article for the purpose of sale, importation of such article without the written consent of registered proprietor, or publishing such article or exposing terms of sale with the knowledge of unauthorized application of design to them also involves piracy of the design. Section 22 of the Design Act deals with the piracy of registered design and provides the legal proceeding to be followed in case of piracy of design, registered design. It is to be noted that uh, there should be registered design. Any unregistered design cannot be protected under the law. So section 22 says, during the existence of copyright in any design, it shall not be lawful for any person piracy of registered design. Clause A say, for the purpose of sale to apply or cost to be applied to any article in any class of article in which the design is registered, the design or any fraudulent or obvious imitation thereof, except with a license or written consent of the registered proprietor, or to do anything with a view to enable the design to be so applied, or to import for the purpose of sale without the consent of registered proprietor any article belonging to the class in which design has been registered, and having applied to it design or any fraudulent or obvious imitation thereof, or knowing that design or any fraudulent or obvious imitation thereof has been applied to any article, to any class of article in which design is registered without the consent of registered proprietor, to publish or expose, or any cost to be published or exposed for the sale of that article. Subsection 2 say, if any person acts in contravention of this section, he shall be liable for every contravention. Clause A of subsection 2 say, to pay the registered proprietor a design or sum not exceeding 25,000 rupees recoverable as a contract debt, or if the proprietor elects to bring a suit for recovery of damages for any such contravention, or for any injunction against the reputation thereof, to pay such damages as may be awarded, to be restrained by injunction accordingly, provided that the total sum recoverable in respect of any one design under clause A shall not exceed 50,000 rupees for one design. Provided further that no suit or any proceeding for relief under this subsection shall be instituted in any court below the court of district judge. So it is clear, suit for infringement or piracy can only be filed before district court, before district judge. District judge is only eligible to hear the design suit. And in design suit, we may seek interim relief. We may file interim interlocutory petitions such as under CPC, Order 39, Rule 1 and 2 for interim injunction against the pirater. Subsection 3 of Section 22 of Design Act says any suit or any other proceeding for relief under subsection 2 says either ground on which the registration of design may be cancelled under section 19 shall be available as a ground for defense. Suppose if you file a suit against the pirater, a wrongdoer, and the pirater, the defendant, file a cancellation petition for cancellation of your design. Now, this subsection talks about that in any suit or any proceeding for relief under subsection 2, either ground on which the registration of design may be cancelled under section 19 shall be available as a ground of defense. Subsection 4 says, notwithstanding anything contained in the second proviso of subsection 2, where any grounds or which the registration of design may be cancelled under section 19 has been availed as a ground of defense, and subsection 3 in any suit or other proceeding for relief under subsection 2, the suit or such proceeding shall be transferred by court in which the suit or such proceeding is pending to the High Court for decision. Subsection 5 says when a court makes a decree in suit under subsection 2, it shall send a copy of decree to the controller of design, who shall cause an entry thereof to be made in the register of design. Because controller is ultimate authority to maintain the register of design. In there are some case laws. Now I will go through some case laws where honorable courts deals and about the what is piracy and whether it is infringement of design or not. In case of Crocs Incorporation USA versus Liberty Shoes Limited, in this case, facts of the case was from 2014 to 2018, Crocs filed several suits for infringement of its registered design, seeking a permanent injunction against the defendant, restraining them from infringing the design of Crocs footwear. Now, before the court, issue was whether the plaintiff's design was in the public domain prior to the registration or not. The court appreciated the evidence placed before it by the defendant, put forth evidence that true a design like a design of Crocs had been disclosed in around 2003 by Holy Shoes and also by Crocs itself on its website in 2002. Now, next issue was next issue which the court decided was whether the plaintiff's design was new or original. In this point, the court, while deciding the issue of novelty and originality, held that registered design of Crocs with respect to its footwear did not have necessary novelty or originality for it to be granted protection under the Act. So accordingly, the court observed that registered design of plaintiff is liable to be cancelled as per section 19 subsection 1d of Design Act, read with section 4a subsection 2 of Design Act, which say that prior publication and all this. So court, while dismissing the injunction, which was filed by Crocs, uh, awarded a cost of rupees 2 lakhs, in addition to legal cost incurred till date to each defendant. So in this matter, court say that only uh, the design which is not priorly published till the date of registration, or if any design which is already available in the market is already in public domain and anyone file for registration of that design, although it may be registered, but if anyone have any grievances against that design, they or he may file a application for cancellation of that design on the basis of that design, that impugned design is already available in public domain prior to the date of publication. Now, in another case, in Cello Household Products versus Modeware India and others. In this case, the facts was that case was filed by the popular household products, as we know very well, Cello, against the Modeware India, seeking an injunction for design infringement and passing off. The dispute was over the copying of design of a bottle named Puro, launched by plaintiff in the year 2016. The bottle was two-toned color with a certain specific phrases and words. The defendant launched a similar bottle called Kudos in a following year, for which they were sued by the plaintiff in present matter. Issue was subject matter is infringement of design of bottle launched by Cello, for which company has invested ample money in the market for selling and marketing purposes. Honorable Bombay High Court in this matter observed that court on the basis of merits decided that the plaintiff was justified in filing the suit against the defendant, as Modeware India introduced a bottle which is deceptively similar to the bottle of Cello and denied defendants' contentions of lack of jurisdiction of Bombay High Court to decide the case, following grant interim injunction and relief to be given by the defendant to the plaintiff as damages keeping the loss faces by the plaintiff. Therefore, Cello won the case. So in this matter, we can say if design fulfill all the ingredient which already we have discussed, it should be novel, it should be it should be novel, and it should not be available prior to the date of application. So if all criteria fulfill, it can be registered and court may grant uh, injunction against pirater or against wrongdoer. So in this way, there are numbers of cases which already honorable high court and has decided different high courts and Mumbai High Court and as well as Delhi High Courts, in which it specifically mentions that design is a statutory right. It's not a common law rights. It's a statutory right. It's only available when the design is registered under the Design Act 2000. If any design which is not registered and is available on public domain, if the proprietor of that design wants any legal remedy, they cannot seek under this Design Act. Now, friends, if anyone have any question, if you have any question in respect to the design, and you may ask, I
Thank
will
you, sir.
reply.
Thank you for your wonderful explanation and the run through of the Design Act as well as the registration processes. At this point, we do have some questions, but again, I'd like to ask the chat. I'd like to ask the audience to please send in their questions if they haven't already to the chat box. And secondly, if you haven't filled in your attendance sheet, please do so. So our first question comes in from Chaitanya, who asks. What challenges one can expect on the expanded protection for building and interior designs under the revised Design Act?
Building constructions is not under this purview of the Design Act. So you can get it under Copyright Act.
And interior designs as well. Would that include interior
Yeah,
designs as well,
interior
sir?
design is also you can get it registered under design under the Copyright Act, not under
Okay,
Design Act.
thank you. Our next question is from Shivani, who asks, why is there a overlap between design and copyright laws?
No, it's not an overlap, but it's we can say it's a design and copyright are the two aspect of IP rights, intellectual property rights. There are two wings. So I have already differentiated that what is the design and what is copyright, because copyright is only subsist when the any copyrighted work come into the existence. Okay, whether it is registered or unregistered, it is immaterial. But in case of design, only registration is important. If it is not registered, we cannot enforce our legal rights under the Design Act. So it's a very important that in every design there is a copyright. There is a copyright, but copyright is the exclusive use of that design by registering it. If you have not registered, you cannot claim any monopoly over that.
Okay, I hope that answers your question. Our next question is from Jay, who asks, can you explain the interplay between Indian Design Act and the trademark law following difficulties faced with 2D and 3D during the registration process?
No, in design, we have already defined that as per the section 2D, design should be a 2 dimension or 3 dimension. And trademark and design is totally different. Trademarks acts deals about the registration of trademarks, which can be a name, logo, any shape also. But if we differentiate in this design, we can say that design should be aesthetic, that it is visible, it is usability should be in suppose if you want registration for any particular items, you should have a novelty. In case of a trademark, if you are using that trademark from the so many years, and you may apply for that for registration, you may not apply for, you may use it, you will have a remedy for a law under law of passing off. But in case of design, you should have a registration, and prior to adoption of the design, you should have registration, meaning thereby if you created any new novel article, if you created a novel um, machine or no novel item, suppose novel goods, you may get it registered first. Thereafter, you may use it. You may you may take it on public domain. But in case of trademark, if you are using it since last 2 years, 3 years, you may file it. There is no restriction at all.
So I think keeping in line with the registration process of a design, our next question comes in is, what is the right time to register a design under the Designs Act? I mean, maybe
Uh,
not specifically under the Designs Act, but in the entire process of coming up with a design as such, when would
yeah.
be the right time to register it?
No, it is advisable to every proprietor. They should apply as soon as possible when the design is created. Before launching it, you should file application for registration of design, and after registration, you may launch in the market. Generally, what happened in India, uh, public invest money on that in the creation of that design. They first circulated in the market whether this what is the cost of this product, whether it is marketable or not. Thereafter they file application for a station of design which cannot be justified, and this so in this way it can be challenged at any at the later stage. Anyone can file an application for cancellation of, even though when you get registration, Anyone can file an application for registration of cancellation of that design. So it is advisable to every the proprietor. They must file application when they created such a design without disclosing any third party, without launching in the market. They should first seek a statutory right. They should file application before the controller of design, and after the registration of that design, you may get it in the market and you may sell, export, whatever you may do so.
I think also the question arises usually when the registration process is happening. Are there provisions that restrict registration of some designs? And if so, are these designs governed? I mean, could the person who created these designs approach some other way to get his design protected?
No, this is the domestic laws. It's only protects Indian continent. So if you want statutory rights under Indian laws, you may file application under Design Act 2000. You will not have any right of design which is created in USA or in South Asian countries.
So keeping in mind the international
Even
design at this, yeah, sorry, sir.
you may get the priority claim, that suppose you have any application which you have filed in USA, and when you want to file in India also, so you will get the priority claim, so benefit of that. But you cannot claim the right of that design which is registered in USA or any other countries.
So that was actually my next question, is that if I get a design registered in India, would it be only protected in India or globally as well?
It is protected in India only.
Only in India. Is there any other procedure that I as a person who's designing a logo that becomes, say, a household name or has the potential to become a household name, is there any procedure that you can follow to get it registered all over internationally, or will it have to be country to country, country to country?
You may file it country to country, because design laws is country specific. It's a domestic law. So if you want protection under in different countries, you may file under different countries for separate application. It is only protected if your application is registered, if your design is registered under Indian laws, that is Design Act 2000. Your design is protected under India only.
I think at this point we are done with the questions. If anyone has any more questions, please do send them forward. We'll deal with them again. Anushka, could you please go to the first slide? So we'll also have Rakesh Tiwari sir's contact information up for a couple of seconds. For you, if you have any queries, please do write him an email and he'll be happy to clear it then. Once again, before we end, I'd like to please remind everyone to fill up the attendance sheet. Otherwise, you will not get your certificate. I think we have one more question coming in. 1 second, so let me just check. Yeah, so Gaurav asks, in case of piracy, who will be considered a pirate? The manufacturer of the pirated product or the seller?
Manufacturer and seller, you may file a suit against both of them. First, first would be the manufacturer, and second would be the traders, that is marketing of that products.
So would one have to file two separate suits, or we could include?
No. Include it is you may file a one suit inserting two defendants against the two defendants.
Thank you, Gaurav, for a question. I hope that your question has been answered. Once again, if you have any further questions, please do reach out to Rakesh Tiwari sir on his email. Rakesh Tiwari sir, I would like to thank you for taking your time off to conduct this webinar. I feel that from my side, it was very, very informative and very, very interesting as such, as the topic is quite an interesting topic. We thank you for your time and effort, and we hope that you would join us for more webinars in the future.
Thank you, Samir, and your LAR team.
Thank you, sir.
You have invited me for a very important topic. Thank you so much. Thanks a lot.
Thank you, sir.
Also, participants, tomorrow we have Rakesh Tiwari sir's second webinar on copyright. So I request all the participants to join that too. That will be equally interesting and insightful.